We've looked at the complete legal system that we have in this country for supporting vulnerable young children and young people and protecting those young people and children. That scheme being the different stages we've considered: early help, child in need, support for looked after children, support for children in care, and support for care leavers. The question remains, what do we do if those legal provisions, so those aspects of the scheme that we have considered, aren't being applied correctly? So what do we do if somebody isn't getting the help that they need, or the help that they are getting isn't adequate or sufficient to meet their needs, or they're not being assessed as they should be, for example? In those situations, we have to turn to public law, which is law that relates to challenging the actions or decisions of public authorities, such as social services, when they don't act as they should in accordance with their duties and powers towards private individuals. The underlying legal principle that we need to understand as a basis is that private individuals are able to do anything that they want to do unless it's prohibited by law. So unless there is a specific law stating that an action is illegal, a private individual is permitted to do anything that they choose to do or want to do. The position for public authorities, such as social services, is the complete opposite. So public authorities are only allowed to do what they have been given a specific legal power or duty to do. They're not allowed to do anything else. The powers and duties that they have are provided to them by Parliament through legislation. So through acts of Parliament, acts like the Children Act 1989. The starting point, therefore, to understand if public authorities are acting lawfully in their interactions with private individuals is to look at the legislation, the regulations, so to look at the law that governs what powers and duties they have towards that private individual. In our case, it's the Children Act and the associated regulations, which are our main sources of law. Just a point on guidance. We touched on this very briefly earlier, but to say that guidance is often thought of as something that is unimportant, that it can be ignored, that it's not something that you need to give much attention or consideration to. But in legal terms, guidance can be very, very important. Statutory guidance, it's guidance which explains how a piece of legislation such as the Children Act should be interpreted and put into practice. And statutory guidance has to be complied with by public authorities unless they can provide a good reason not to comply with that guidance. So we've talked about the working together guidance and how the timescales set out in the working together guidance should be complied with unless local authorities can provide a very good reason as to why they're departing from those timescales. So guidance, when it's statutory guidance, is almost as good as the legislation itself, because it's telling us exactly how a legal power or duty should be put into action by the local authority. Non-statutory guidance is slightly different. So this is issued from time to time by different bodies, might be by government, might be by NGOs or other sort of semi-governmental bodies, and this guidance, non-statutory guidance, is still important, whilst it doesn't have the same weight as statutory guidance, in that it can be departed from, and there isn't that requirement that a public authority must be able to provide good reasons as to why they're departing from non-statutory guidance, it nevertheless needs to be taken into consideration, and it's considered to be one of a number of relevant considerations or factors to be taken into account when public authorities are exercising their powers and duties. So non-statutory guidance is nevertheless also important to look at, and public bodies are required to give appropriate weight to it when taking actions or reaching decisions that affect private individuals. What do we mean by acting lawfully or acting unlawfully for public authorities? How do we know when they're not doing what they should do legally? Well, there are three principles of public law. The first is that public authorities must apply a correct understanding of the law itself, of the legislation, for example, the Children Act, and any guidance. And that principle is a principle called legality. So they must act lawfully or legally. The second principle is that public authorities must apply a fair procedure. So they must act fairly. And the third is that they must act rationally. And again, we'll break each of those down in turn. The second two principles, fairness and rationality, are what we call common law principles. And this means that they've been developed by the courts rather than set out in legislation. Judges, when they make decisions in this country in cases, their decisions then are binding and set precedents in other cases. And in that way, the law is developed and evolves. And common law principles are those which have developed from the decisions of judges in cases. The first of those principles, legality, requires local authorities and public bodies more generally to apply an appropriate understanding of the legislation and to make sure they're acting in accordance with that when they're interacting with private citizens. There are many ways in which public bodies can act unlawfully or illegally, so can fall foul of that first principle. And I'll give you an example of some of those ways that public authorities can act illegally. The first is a principle called ultra vires, which means that public authorities go beyond what they've been given the specific power or duty to do in legislation. An example of this in the context of our young mums and their children would be where local authorities provide Section 20 accommodation under the Children Act to the babies of our young mums without obtaining the informed consent of a mother for that child to be taken into voluntary care, so to become looked after. The reason that a local authority doing that without seeking informed consent of mum would be unlawful is because the Children Act is quite clear that in order to accommodate a child under Section 20 of the Children Act, a local authority must have the consent of the parent to do so. If they tried to accommodate a child without consent, they would be acting beyond what the Children Act allows them to do. So they would be acting ultra vires. Another example of illegality is where a public body acts in breach of its duties. Now, many areas that we've looked at during the course of this training set out specific duties that social services have towards looked after children, care leavers, their children. For example, for children in need and those who are looked after or children in care, local authorities have, under the Children Act and the associated guidance and regulations, specific duties to take into account the views of children before deciding what services to provide. If the local authority fails to do so, fails to take into account the views of children, so fails to seek those views in the first place, and then to actually use those views to help inform any decision that they reach, then that local authority, that public body, has acted in breach of the legal duties set out in the legislation itself. That would be an example of illegality. Another common area of illegality is where public bodies base decisions or actions upon an incorrect interpretation of the law. So they might simply misunderstand what the law requires of them, what they're able to do or not able to do. And an example in the context of young mothers who are looked after or were care leavers themselves and their children that we've seen is local authorities assuming they can only accommodate a mother and her baby by taking that child into care under Section 20. By treating that child as a looked after child under Section 20 of the Children Act 1989. This isn't correct because Section 17 of the Children Act, Children in Need provisions, enable the local authority to accommodate a child together with their family if they want to, and if that would meet the needs of the child. So if a local authority proceed to accommodate a child under Section 20 because they think that's the only way they can accommodate a child, then that would be a misunderstanding or a misinterpretation of the law, of the scope that the Children Act gives them to provide support to vulnerable children. Other examples of illegality relate to the process followed or the scope of investigations carried out by a public authority when they are reaching decisions or taking actions. For example, in assessment processes, local authorities need to undertake comprehensive assessments, take into account lots of information in order to reach a sensible and a sensible conclusion, and in order to be able to analyse the situation properly and effectively. That means that they have to ask the right questions and obtain relevant information. Some local authorities, public bodies, might fail to do so, and if they don't ask the right questions or obtain relevant information, they can't take this into account, and so their assessments will be flawed. One example of a failure to ask the right questions might be operating a blanket policy in respect of care leavers to undertake a pre-birth assessment under Section 47 of the Children Act 1989, i.e. an assessment to determine if the child is at risk of significant harm or is likely to be at risk of significant harm, without having looked at whether that question is justified in the first place in the particular context of a care leaver's circumstances. There might be no reason whatsoever to suspect that a care leaver, just because she's been a care leaver, would be unable to parent her child and might pose a risk to her unborn child. And so the practice of undertaking a pre-birth assessment as standard might be quite problematic. It might involve the local authority having failed to ask the right question, i.e. is this a case that justifies a pre-birth assessment at this point? Following on from the failure to carry out appropriate investigation is another example of illegality, which is a failure to take into account relevant considerations. So a public body might have gathered all the information that they need, but then when it comes to their analysis, they might fail to actually use the information that they've gathered to help them reach a conclusion or a decision which is appropriate to the circumstances of the case. As public law and community care lawyers, we often see assessments where the body of the assessment will contain lots of information, important background information about the circumstances of a particular family, but the conclusions or the decision at the end of an assessment won't have taken a lot of that information into account. And that failure to consider relevant information is an example of illegality. The spin side of that is that sometimes public authorities, when they reach decisions or conclusions, take into account irrelevant information. And that equally is an example of illegality. So where information that has no material impact on the decision to be reached is included in the analysis and in the decision making, that can be unlawful, it can be illegal. Another example of illegality is a failure to comply with statutory guidance. I mentioned that statutory guidance is very important and that it can't be departed from without the public authority providing good reasons as to why they are departing from statutory guidance. If a public body is unable to provide good reasons but has nevertheless departed from statutory guidance, then they are acting unlawfully. An example of this in the context of our young mums and their children might be that a public authority, a local authority, social services has no arrangements in place for the provision of early help in the area. Well, the statutory guidance requires that local authorities make arrangements for early help. And if the local authority doesn't do that, then they are acting unlawfully. So that's the first of our three areas, our three public law principles. First area where public bodies like local authority social services can fall foul of the law. They can act in an unlawful manner towards private individuals. The second is procedural unfairness. Is the principle of fairness. And this is really quite simple in that public bodies have a duty to act fairly towards individuals in their interactions with them. That means that if there are specific procedures set out in the legislation itself, i.e. about how things should happen, for example, in the context of LAC reviews, looked after child reviews, there are really strict rules around how often they should take place, how they should be led, who should be present, information to be considered as part of them. And those procedures need to be followed because they're set out in the legislation and the guidance and regulations. If those procedures are not followed, then the public body, the local authority social services in this case, is acting unfairly towards private individuals, so towards mum and her child. More generally, the principle of fairness requires that public bodies do just that. They behave fairly in the way that we would normally understand it. What fairness requires obviously depends to some extent on the particular circumstances of a case. But generally, fairness includes things like knowing the case against you and having the chance to answer it. So, for example, if a public body relies in an assessment for child in need or for child protection purposes, a Section 47 assessment, on information which is adverse to mum, so they're making judgments or comments or putting information in there which suggests that our young mums are sort of responsible or are behaving in a certain way, but that information is incorrect or that information is only a sort of partial reflection of the truth. The fairness requires that that young mum has the opportunity to know what's being said about her, what information is being relied on, and have the opportunity to actually respond to that and to dispute it if she needs to, if that information isn't accurate. Fairness also requires that if a decision is made, that you as a private individual are given the reasons for that decision so that you have the opportunity to decide whether that decision is justified or not, and if not, you have the opportunity to consider whether there is something that you want to do about it, i.e. to challenge that decision. This is why, as practitioners, as advocates, it's really important if a decision is made affecting a young person that you're working with or their children, and you're not clear the basis or the reason for that decision, that you either directly or you encourage the young person or the child, ask what are the reasons for this decision. And you can ask for public authorities to set those reasons out in writing if you do have any cause for concern about the decision reached. Another example of fairness is where public bodies have particular policies in place which set out how they have decided they will act in a certain situation, or when they're faced with a certain kind of client or a certain kind of need. You can expect, if they have those policies in place, that if you meet those criteria, if you are that kind of client or you have that kind of need, that the local authority will behave in that way towards you. If they don't, then it would be unfair. If they've set out a particular policy or procedure or practice that they're going to apply and then don't apply it in your case, then that can be an example of unfairness. And the third of our general public law principles is irrationality. So where public bodies interact with private individuals, they're required to do so rationally. And if they act irrationally, then their actions are legally flawed. Irrationality is a difficult concept in law. It's not irrationality as we might use the word generally in day-to-day conversation. It means something more than unreasonableness or more than a position that we might disagree with generally. It's not the average person test. Irrationality for public law purposes means something that a public body does where no other public body in the same situation would have done that. So it's something that is so unreasonable that no reasonable authority would have done the same in those same circumstances or when faced with that same information. This means that for public law purposes, it's quite an unusual threshold to meet because it's a very high threshold to meet. So there won't be many cases as public lawyers where we'll be arguing that a public body has acted irrationally. That said, it does happen, and there are cases that succeed on that basis, but most public law challenges will be based on legality, illegality, or fairness, unfairness principles. If a public body, a public authority, acts in breach of those three key principles, so acts illegally, unfairly, or irrationally, then private individuals are able to challenge their actions or decisions by way of judicial review. I explained earlier in this series of webinars that there is no appeal as such from the decisions of social workers when they are interacting with our young mums or their children and making decisions about their lives. The only legal mechanism to bring a challenge to those actions or decisions in the courts is by way of judicial review. And in a judicial review, the court won't be looking at the merits of a situation. So they won't look at, on balance, has the public authority made the right decision? Would another decision have been better? The judicial review process is limited to a court considering if a public body has acted lawfully, i.e., have they acted legally, fairly, rationally? If they haven't, then a public body will be found to have acted in breach of an individual's rights. So they'll have been found to have acted in an inappropriate manner towards an individual. and their actions or decisions will be unlawful. If there were only two alternative outcomes that could have arisen in any particular situation, and the public body is found by the Judicial Review Court to have chosen the wrong one, so to have acted unlawfully, then the court in judicial review can substitute the action or decision of the public body for the right decision, for the lawful choice that the public body didn't make. However, this is an area, the actions or decisions of social services, where in reality there's often many, many different outcomes that could have been reached following an assessment or a decision about how to progress the care or how best to support a vulnerable child. For that reason, in most judicial reviews, the court will remit the action or decision to the local authority or to the public body once they find that the public body has acted unlawfully. That means that a outcome of judicial review can be that you as an individual win a judicial review, the court says the local authority's acted unfairly and instructs the local authority to go away and do whatever it is that they've done wrong again. The local authority might do that and reach the same conclusion as they reached before, but do so having taken into account the right considerations or having followed the correct process. And then that decision would be very difficult to challenge. That said, whilst that is an outcome that can happen, it's quite an unusual thing to happen, and often a ruling against a public body in judicial review will encourage that public body to go away, do things more carefully or properly, and often it will result in a different action being taken or a different decision being made at the end of their processes. Judicial reviews are heard by the High Court or the Administrative Court rather than the Family Court. So this is a procedure that happens in very senior courts in this country. And for that reason, specialist advice is generally required by an individual seeking to bring a public law action, so to bring a challenge to a local authority's or public body's actions or decisions on the basis that that public body has acted unfairly, unlawfully, unfairly, or irrationally. Judicial reviews can only be brought against public authorities, and they can only be brought against public authorities who are exercising their public functions. So local authorities, for example, have many, many functions, some of which are public, for example, the provision of social services, social care to vulnerable individuals, including young mums and their children. But they also have private functions, so they might be allowed to engage in sort of contracting or entering into agreements on a private basis. Those actions or decisions are not within the scope of judicial review. So judicial review is simply a process that allows the public functions of public authorities to be analysed and scrutinised by the court. The court in judicial review won't consider academic cases, and by that we mean cases where the issue is no longer impacting on the individual, where the matter has now been resolved, except in very exceptional circumstances. So if there's a wider public interest issue raised by a particular case, then it might be that even if that case has been resolved so far as that individual is concerned, the court will nevertheless consider it appropriate to go on to decide the case and to examine and scrutinise a public authority's actions so that they can set a precedent which will then apply to that public body, public authorities' actions, decisions in relation to other individuals, or the actions or decisions of other public authorities who are doing similar things. A judicial review can also only be brought as an action of last resort, and that means that if there is something else that could be done to resolve the issue, that needs to be done first. That means that where, as in the case with health and social care, decisions there are complaints procedures which can be followed, that a court will want to know why those complaints procedures haven't been followed, whether they would provide an effective remedy instead of an action of judicial review being brought before the court. I want to say at this point, don't be dissuaded from talking to your clients, the people that you work with, about judicial review in favour of sort of pursuing the complaints procedure, because it might be that the complaints procedure in a particular case would not provide an adequate alternative remedy. That's because sometimes complaints procedures can take too long, and if there's something which is urgent and a young woman is without the care and support that she needs at a particular time, or her child is, then the complaints procedure might not be effective in resolving that, or it might be that the complaints procedure would result in a local authority acknowledging that they haven't followed a process very well, or engaged particularly constructively with the young person, but might not involve them actually really scrutinising and looking at the impact of that, or the ultimate outcome of the action or decision that they've taken. And a judicial review would do that, would look at the legality of the action or decision. So it's a very difficult decision as to whether the complaints procedure or judicial review would be appropriate in a particular case. If in doubt, would strongly encourage you to speak to the people that you're working with about seeking specialist advice from a public lawyer who can look at a particular case and advise whether complaints procedure or judicial review would provide the remedy that is needed to resolve a particular issue that person is facing. Very important things to remember about judicial review relate to the timing in which a judicial review action or decision, in which a judicial review has to be brought in respect of an action or decision by a public body. The underlying principle is that it has to be done promptly, at the absolute latest within 3 months of the date on which an action or decision was taken. Now, that doesn't give us very long to challenge the decisions or actions of public bodies. That means if you're working with individuals who are concerned about how the public body is interacting with them, who are concerned that a public body might be acting in a way which is unfair or irrational, or the public body hasn't taken into account relevant considerations, who might be acting illegally, they must seek advice and take action expediently, because if they don't, they could be timed out of bringing a judicial review action which might hold the local authority to account and give the court the opportunity to scrutinise the local authority's behaviour and the opportunity for that young person to receive a remedy to resolve their issues. Sometimes even that 3-month outer limit can be too late to start proceedings, and that can be because it might be that if you're, for example, arguing that a local authority has failed to give consideration to a particular kind of placement and hasn't included that as part of their considerations, that placement, which might have a place now, doesn't have a place in 3 months. So you might find that even if you were to issue proceedings, that actually it would be too late, because there would be no remedy that the court could provide that would help a person in that situation. So the message really that I'm trying to convey is it's really important to act quickly. And if in doubt, get advice for the vulnerable person early. Another issue relating to timing of judicial reviews is that sometimes situations are so serious that even before the judicial review is properly heard in the court and all of the information is put before the judge, something needs to be done to protect your client, the vulnerable person, and you might need to ask for an injunction from the court or an order requiring that a public body do something immediately to ensure a person's safety, well-being, welfare. For example, you might be asking for a public body to accommodate a person pending the judicial review being decided. So sometimes it's necessary to ask for urgent support, and sometimes it's necessary to ask for the whole case to be expedited, i.e. to be heard very, very quickly, to ensure that your client's position is not prejudiced in the meantime, that that things don't move so far that they would never be able to get an outcome which would resolve the issues around which the case is brought in the first place. The procedure for bringing judicial review is that first a pre-action protocol letter or letter before claim is sent to the public body, and that is a very detailed letter which sets out why it is contended that the action or decision of a public body is unlawful, i.e. it is illegal, unfair or irrational, or a combination of those things. That letter it's usually drafted by a specialist public law lawyer because it needs to set out in a very prescriptive format exactly what the decision is that's challenged, why it's challenged, and why it's being suggested that a public body has acted in an inappropriate manner. If a response is not received to that letter, or the response received is inadequate, then an individual can go on to issue proceedings. Those proceedings have to be issued within, at the absolute outset, by the absolute latest, within those 3 months of the action or decision being taken. So it's a really, really, really fast process. Once a set of proceedings have been issued, there are 2 stages to a judicial review. The first is the permission stage, and the second is the full hearing. At the permission stage for judicial review, the judge will consider the legal arguments set out in the papers that have been submitted. Sometimes there'll be a hearing, but often it's just considered on the papers whether this is a case that's capable of succeeding. So whether there's a chance that the claimant will prove that a public body has acted in a way which is unlawful, unfair or irrational towards them. If the judge decides that this is a case that could succeed, permission is granted for the judicial review to continue, and the case will then go on to stage 2, which is a full hearing. If the judge, however, decides that this isn't a case where the permission should be granted, where the court is likely to be persuaded that or is capable of being persuaded that the public body has acted unlawfully, then permission will be refused, and that will be the end of the case. If the court does decide permission is granted, a full hearing will be convened. Now, judicial review hearings are unlike other kinds of hearings that you may be more familiar with. For example, hearings in the family court where people give evidence, witness evidence where people are examined, cross-examined by barristers, where there is a lot of sort of legal argument and debate. That doesn't happen in a judicial review hearing in the same way. Most judicial reviews, the evidence is all submitted on the papers, it's extremely rare for there to be any witnesses who need to give evidence in person to be cross-examined by the opposing side's barristers. Usually, all the evidence is there, prepared by the solicitor in a bundle, and evidence from the other side is also included in that bundle, and their legal arguments. And barristers who are advocates who present the case to the court simply use their oral arguments to expand on points in their written arguments and to point the judge towards particular bits of evidence. The judge will sometimes ask questions of the barristers, which the barristers will then answer to help the judge have a clear understanding of what the case is all about and why it's said that a public body has acted unlawfully if you're representing the claimant, or why the public body is defending the case and arguing that it hasn't acted unlawfully towards that individual. And it's really, the process is all really about legal arguments rather than sort of factual analysis of what's happened. As I said before, it's not a set of proceedings where the judge will look at the merits of a particular action or decision. The judge is looking at the legality of that action or decision. So it's a very, very niche, specialist kind of proceedings. That is judicial review and public law in a nutshell. And that brings to a conclusion this series of webinars about support for vulnerable children, vulnerable young mums who are looked after or have been looked after in the care system. The key message is that if you are representing a young person, working with a young person, and you're concerned that they're not getting the help or support that they need, then do seek advice or help them to seek advice from a specialist. Community care and public law do still fall within the scope of legal aid, and there are legal aid lawyers out there specialising in this particular area of law. And those lawyers are able to provide advice to young people, young women and their children about the legality of the actions or decisions of public bodies, i.e. social services, and the way that they are being helped or the way they're not being helped. Remember that legal scheme is what local authorities, what social services are required to do. So that's the way they are, that Parliament has decided that they should support these young women and their children. Where that's not happening, these young women and their children have a right to seek advice and potentially to take action to challenge the local authority social services. Thank you.